night on the CINA 102.3 app at CINAFM.com, on TuneIn, on smart speaker, and at 102.3 FM. CINA Radio, every device, everywhere. The following program does not necessarily reflect the opinions of the management, staff, or advertisers of CINA Radio.
Joumana Kayrouz. You've seen her images on giant billboards across the metro. Joumana Kayrouz. You've seen her images on buses across the city. Now get to know Joumana Kayrouz.
The war broke out in my home country, Lebanon. I was 11 years old, and I saw a lot of bloodshed and inequality and poverty. You can't grow up in an environment like that and not be affected by it and not want to make a difference. I graduated from Yale University with a master's in ethics. I speak 4 languages. It has always been innate in me fighting for the underdog and trying to do whatever it is I can to make a difference in the world.
Let Joumana Kayrouz protect your rights. Call the law offices of Joumana Kayrouz at 1-866-YOUR-RIGHTS, extension 100, or visit yourrights.com.
برنامج يور رايتس مع المحامية جومانا كيروز المختصة في قضايا حوادث السيارات، مع نخبة من المحامين في اختصاصات عدة منها الطلاق والهجرة والإفلاس، يأتيكم الآن على الهواء مباشرة.
تحية طيبة لكم مستمعينا، أهلا وسهلا بكم في حلقة جديدة من برنامج يور رايتس مع المحامية جومانا كيروز، وأكيد موضوع جديد على الهواء مباشرة. جومانا أهلا وسهلا.
ومحاميين مش جديد للمكتب، بس وحدة منهم جديدة إلى الراديو. صباح الخير
صباح
رامي.
النور.
يعطيك ألف عافية. صباح الخير للجميع. إن شاء الله يا رب إنه رمضان عم بيمرق مش بصعوبة على المستمعين. رامي اليوم إذا بتسمح مش رح نتلقى اتصالاته لمدة ساعة. مستضيفة محاميين من المحامين اللي بيشتغلوا عندي بالمكتب، المحامي مارك غزدكي اللي هو بيدير الكريمنال ديبارتمنت والفاميلي لو ديبارتمنت عنا بالمكتب، والمحامية كيتي بليغ اللي هي مساعدته وهي كمان محامية بالكريمنال ديبارتمنت وبالفاميلي لو ديبارتمنت. Thank you, Rami. I want to welcome into the show attorney Mark Gazdeki, who heads the criminal and family law department in our office. Hello, Mark.
Good afternoon, Joumana.
Good afternoon to you. And for the first day today, one of our associates who assists attorney Mark Gazdeki in our criminal law department and in our family law department, attorney Katie Plague.
Good afternoon, everyone. It's such a pleasure to be here. Thank you, Joumana, for having me, and to all of our wonderful listeners.
It is a pleasure. And you promised that you're not going to talk very fast. So I hope that you will be able to keep your word.
I'm going to try my best.
Happy to have you. Looking forward to spending the full hour, God willing, today, and the full hour, God willing, next Thursday, talking about family law matters and about criminal matters. Attorney Katie Plague, you have been the lawyer who has been handling a number of the calls. You screen the calls after they get sent to your department from our head receptionist. Is that correct?
That's correct, Joumana. I spend a lot of my time in the office speaking with our clients and potential clients who are calling into the firm who need help in one way or another. And they come to me first to see if they have a viable case, what is the likely outcome of their case. Is it a family law or a criminal law matter? Perhaps it's best suited for another attorney in our department, and I give my best assessment at that time, and this is all before meeting with the client.
Okay. And Attorney Mark Gazdeki, I don't want you to be too polite, and when you need to say something, you have 2 ladies today, and it's very easy for the 2 of us to take over. So you have to fight for your airtime, and we need it because of your experience of 20-some years doing what you do. So, Mark, I urge you not to hesitate to speak up when you need to.
Thank you, Joumana. I'm truly blessed with 2 beautiful women today, guys.
That is very true. 2 very beautiful women. Might we add, highly intelligent, very decent women.
Absolutely. Because brains are just as important as looks. I think everyone in this room will agree to that.
Actually, it's very hard to live in today's world. Here in the United States, there are laws that pertain to everything. That's number one. And we are living in an increasingly technological society. So not working on yourself it cannot get you very far. Even if you don't want to work out there to raise your children, you have to be involved, you have to be informed to a certain degree in today's world. In my days, it was way simpler. There were no phones, there were no computers, there was no social media. It was much, much simpler. And my mother and our mothers in my generation did not need to be as informed as mothers need to be today. My mother didn't need to sit down and watch my computer use, and she taught me how to be a good human being, how to be a godly person, and so forth. But nowadays, that's very important. That's probably the most important, but it's not enough.
I think you're 100% correct, Joumana, your assessment of today's society. And I think you touched on a couple really important points that Mark and I see raised all the time, in particular with our family law issues. Number one, regarding technology and increasing use of social media. Absolutely.
Okay, Attorney Mark Gasteki, what do you have to say about that? I know the use of social media in car accidents is front and center. We discuss it with each and every one of our clients. And now you're telling me in family law as well?
Oh, family and criminal, Joumana. Like I mentioned in a blog we had a few weeks ago, Michigan State has adopted a new law that's for bullying.
The cyberbullying.
Yeah, the cyberbullying. And I've had, through my fiance, I've spoken to her teenage sons, and I said, I look at their text messages just to see what they normally say to each other, and I said, you have to be real careful. That could have been misconstrued, and that could have been considered bullying.
Can you begin, Attorney Mark Gasteki, and Attorney Katie Pegg, feel free to, chime in. Can you begin by telling our listeners, because we have not discussed yet the laws pertaining to cyberbullying that got enacted by the state of Michigan not very long ago. Can you explain it in plain terms, please?
Under the law, the states that for first time cyberbullying charges a 93-day misdemeanor. You can have.
What is a cyberbullying? What is cyberbullying? What is a charge for cyberbullying?
Yeah, cyberbullying is basically you're either threatening a physical act, or you're putting down a person through either their gender or their physical ailment, or just I'm going to meet you later on after school or out in the parking lot, and I will hurt you. If the receiver of that message feels like it's a possibility or that they will do it, that is technically cyberbullying. And what that person, the receiver, can do is go to their local police station and show that message to their detective, who can take actions after that.
So let me go over the definition, Attorney Mark Gasteki, of cyberbullying again. If someone is being threatened with a physical act that will harm them, or if you are being put down, can you clarify a little bit? Put down in what way?
Psychologically. Like, see, this law was instituted back in 2017, I think it was. Yeah, I think it was 2017. This female student in a high school, she received numerous text messages from people in her school, and she couldn't take it anymore, and she committed suicide. And then there was prosecutors looked into it. There was nothing they could do. There was no crime on the book at that time saying.
So you want to talk about living in modern times with modern day technology. Growing up, we had no cell phones, and no one could threaten us via the use of cell phone.
And additionally, folks, just so you know as well, there's another charge that a recent client of ours was dealing with out of Rochester Hills District Court that they took very seriously, which was malicious use of a telecommunications device.
So before we talk about that, I want to go back to cyberbullying for a minute.
And they go hand in hand sometimes,
yes,
Joumana.
And I want, as soon as we finish clarifying the definition of cyberbullying, so putting down somebody psychologically by abusive words, that is also called cyberbullying. Okay. And there is a charge for it now. Is it a misdemeanor or is it a felony, Mark? Okay.
It's a 93-day misdemeanor.
Okay. So misdemeanor. And the threatening, it can be in written, such as via text, or it can be oral.
Yes, because under the technology now, you can send a little video or a text or an audio file through the phones. So it could be all three or one of the three. Also, the law states that if the person responds to the message by hurting themselves, now we're up to a felony.
So if the person hurts themselves, I do apologize, I'm writing this down. Now it rises to the level of a felony. You said, Attorney Mark Gazdecki, that back in 2017, a young girl was it you, Katie? A young girl was bullied and committed suicide. Were there no laws on the book in 2017?
No laws at the time. That's why it took 2 years for our legislature to institute the law.
Was that in response to that very particular scenario and probably others? But would you say that the suicide of that young girl prompted a change in the law?
It did.
Attorney Katie Plague, you said hand in hand with the charge of cyberbullying. And again, to clarify, it can be oral, it can be in writing, it can be threatening a physical act, it could be putting somebody down psychologically. There is now a law on it that got recently enacted, and I want to say maybe a couple of months ago?
About a month and a half ago.
Okay, that gives it rise to the level of misdemeanor. However, if the person hurts themselves, it can give rise to a felony charge. You said hand in hand with cyberbullying, there is another charge. And what is it called?
Just last year, our firm defended a client who was charged with malicious use of a telecommunications device in Rochester Hills.
So, explain what is the charge of malicious use of a telecommunication, and is that state law?
It is. It's a Michigan state law.
Okay, so malicious use of a telecommunication
device.
Correct. And the telecommunication can be a phone.
Correct. Most often it's with people doing harm to another in some form, and it is a very broad definition of the state legislation that's on the books. There are many ways that someone can be found culpable of this criminal act.
So you said this is a new law?
To be honest, Joumana, I'm not sure when it's enacted.
Mark,
it's certainly not as
Mark,
new as
do
the
not
cyber.
hesitate to interrupt, please.
It's not a new law. It's just a law that the prosecutors are more and more
using more and more now than ever.
And
in our
case, bargaining chip.
Yes, it was for a woman who was making repeated calls with her cell phone, and so it can be achieved through calls that are made, text messages that are made, postings that are made. This one is only this is a misdemeanor as well. It's a 180-day misdemeanor, so it's a 6-month misdemeanor. And what we want our listeners to watch out for.
Bullying is 93 days, or it can become
until
a felony.
It rises. Correct.
But the malicious use of a telecommunication device is also a misdemeanor, but it is
80-day misdemeanor. So a 6-month misdemeanor at the outset, which means that's the maximum that the judge is allowed to sentence someone who has been convicted of this offense.
And Attorney Katie Plague, take us briefly, while respecting obviously people's privacy, over the scenario that we had last year. Was our client charged with the malicious use of a telecommunication device, or was she the victim of?
She was charged with malicious use of a telecommunications device due to some repeated calls that she made. And, of course, we're going to respect this client's privacy. And additionally, resisting arrest was added to her charge because she had a scuffle with law enforcement when they responded to these repeated calls and came to her home.
What was the outcome of that case?
I am very happy to report that after several months in pretrial proceedings and a matter that we thought was going to take to trial, eventually we were able to settle this case for this client, where she walked away
with a reduced charge.
With a reduced charge, Joumana, that's correct, of disorderly person.
And was that the case because she had an otherwise clean record? So the law, generally speaking, always gives you a first chance.
Not always, Joumana, but Almost always.
Okay.
Always, more often than not. There are a lot of state legislation in place that protects people who their first or maybe even their second criminal offense. In this case, yes, she was able to walk away with a reduced conviction of disorderly person. She did absolutely no time in jail, and in this case, she did not even have to report to probation. It was a closed case walking away. She had the opportunity to report to probation, and perhaps it would have come off her record at the completion of probation, but she didn't want to have anything to do with the police department or with the probation department moving forward, so she took the 93-day conviction and walked away. That was her choice that we were able to negotiate for her after months of pretrial proceedings.
However, of a disorderly person. Congratulations on a good outcome, and I hope that this person has learned her lesson. Do you believe that she did?
It was a very emotional time for our client, for sure. I think she learned a lot of important lessons, and incidentally, because I came to know her very well through representing her, it had to do with a family law matter, which led to this criminal charge. And if you'd like, Joumana, I'd like to just speak for a couple minutes about how social media is impacting our family law cases as well.
And before we jump into that,
okay,
I'm going to translate this quickly in Arabic, but go ahead, Attorney Marcus Taki.
For our viewers,
listeners,
for our listeners' help, what was some of the things she was saying on the telephone that triggered her, triggered the police response?
There was some swearing involved, unfortunately, and it was more so the repeated calls that occurred over the course of an evening, repeatedly, whereas
one evening only?
Yes, ma'am. Yes, Joumana, that's correct. Only one evening over the course of a couple hours led to this criminal charge, unfortunately, and there was some foul language involved. It wasn't just the foul language that triggered it, but what I want our listeners to know is this law is very broad, and there is language that even includes annoyance. If you are purposefully and with malicious intent contacting someone or using your telecommunications device, with more often than not is a cell phone, if you're doing something on purpose to even as innocuous, as little as annoyance, and there's many other terms as well, including harass, intent to harm, things like that. But what we want our listeners to be careful with this charge is it's becoming a real
increasingly used.
Correct, by prosecutors.
With the advent of technological devices.
That's correct.
Attorney Marcus Daghi?
Yes. Well, see, that allows our listeners, thank you, Katie, it allows our listeners to be very careful being on the phone, because I could see, just from what you were just saying, I could see your neighbor being very mad at you for blocking their driveway and calling you on their cell phone saying, move your car.
Or texting. Or anything, or even minor as that.
You don't move your car, I'm going to go out there and take my key to it and scrape it.
Oh, absolutely.
Now I just committed a 180-day misdemeanor.
That's correct.
So let's just say that it may be easy to fall a victim to being accused of maliciously using a technological device.
That's correct.
Okay.
Absolutely.
So we do not want our listeners to become the victim, such as the lady who used our services, who only over one night was calling repeatedly someone. Yes. She used a little bit of foul language, but that was over one night only.
2 hours only.
2 hours only. And that resulted in her case in the filing by the other person in the city of Rochester Hills.
That's correct.
With a charge of malicious use of a telecommunication device. So if I'm hearing correctly, I'm hearing that very little can open someone up to this charge, and we don't want that. We don't want. This lady, no doubt, was upset. She paid us money, so she did not win in any way. There is something on her record that was not a win for her, in the sense that we don't want people to do this. We don't want them to find themselves accused by someone who does not wish them well, when the law says purposely annoying can give rise to being charged with this charge. Am I correct?
That's all correct, Joumana. And just as a side note, I like to say that anytime our clients can walk away and go home from a criminal proceeding and they don't have to spend any time in jail, personally, I consider that a win. That's what I work for in every case. And there are many mechanisms that you can use, especially with folks who have otherwise a fairly clean criminal record. So I was very happy with the ultimate outcome in this case, but you're absolutely right, Joumana, that it was about 6 months of this woman's life that she was going through these criminal proceedings and repeated repeated court hearings and having to hire an attorney to get through all of this. So you're correct that I'm certain she did not feel like it was a win, but I was proud of our firm's work and the outcome of the case.
No doubt, because as a criminal law attorney for you, Katie, and for you, Mark, the first thing you want is people not to do any jail time or any prison time, and you work from there. No question about it. Whatever the best outcome below that.
Yeah, we want to be able to get the just outcome. It's like being overcharged.
That's right. There is such a thing as being overcharged.
You see,
that was aggressive.
Yeah, see, that's what
this lady being charged when she only engaged in this behavior for 2 hours with malicious use of a telecommunication device.
Correct.
It's a bit of an aggressive.
Because that's one thing as advocates we do, especially in criminal law. It's like my criminal law professor said, we are soldiers of the Constitution. So one of the things that we have to do is when we go before the prosecutor, before we see a judge, we want to get to the prosecutor and like we said earlier about relationships, sit down with that prosecutor and say, hi, Sam, or hi, Sarah, nice to see you again. I have this client, and I think this is overcharged. Let's talk about the situation. Let's come up with a just and, solution that can, what this person really actually did.
And to that point, I think you raised another important point, Mark, about relationships and about communications with the prosecutor. And I know, Joumana, you and I were talking about this earlier off air, but I was saying that I've found in my experience how important as a criminal attorney to be cordial and cooperative and kind in almost all proceedings, criminal and in family, with the other attorney, because the outcome more often than not is relying on those relationships. You want to endear yourself to the prosecutor or the judge that you're in front of so they're more comfortable giving you a better outcome. Now, that's not the law. That's just personal relationships that you learn along the way.
How do you balance that with advocating for your client and reducing the charges as much as possible or having them dropped? How do you balance these two?
So in my opinion, Joumana, and Mark and I have discussed this at length as well, a big part of that is having awareness of the court that you're walking into, the prosecutor's office that you're going to be dealing with, and the judge who you're going to be standing before. Because Mark knows this more than anyone after so many years of practice, over 2 decades experience. One charge in a Wayne County District Court is going to be a much different outcome than in that very same charge was charged in an Oakland County District Court, with Macomb kind of falling somewhere in the middle. And those are the 3 courts we most often practice in.
That's very accurate observation.
How important is the judge in a criminal matter versus the prosecutor?
Extremely.
Why so?
Because the judge is the king or queen of their courtroom. The prosecutor, you could work out a beautiful, just deal with the prosecutor, and the judge will look at it and say, no.
How often does that happen?
Not that often. What usually triggers the judge to change their mind and not go with the agreement that the prosecutor and the defense has had is if they see something in our client's record that just stands out to them and they say, well, I understand your position, I understand the prosecutor's position, but as a judge, I also have to take into the equation the safety of our community, and I believe that this outcome is more just than what you two came up with.
With your permission, before we move to the use of social media in family law, Attorney Katie Blake, I'm going to take a few minutes and have a quick Arabic discussion with Rami about these 2 charges. رامي المحاميين الموجودين اليوم المحامية كيتي بليغ ومارك كازداكي. مارك كازداكي هو مدير الديبارتمنت تبع الكريمنال لو والفاميلي لو، والمحامية كيتي بليغ بتشتغل تحت ايده. حكينا اليوم عن قانون جديد وحكينا عن قانون قديم رامي صار المدعي العام عم بيحب يطبقوا أكتر من قبل. هيدول الاثنين عم بيصيروا موجودين بسبب استعمال التكنولوجيا، بسبب انه كل انسان صار عنده تليفون، the incidence of abuse، نسبة انه انسان abuse اللي عنده إياه عم تعلى أكتر وأكتر. وحدة منهم هي بيسموها the cyber bullying law. bullying يعني ما بعرف بالعربي التنمر. cyber bullying يعني عبر التكنولوجيا،
صح، عبر الإنترنت.
بيخبرنا المحامي ماركس ذكي إنه في بنت حرام بال2017 بولاية ميشيغان تعرضت للبولينج كمان مرة بالعربي التنمر رح اكتبها التنمر وبسببها ارتكبت الانتحار. she committed suicide. بهيديك الأيام ما كان في قانون لحتى يطبقوه ضد اللي ارتكب التنمر واللي وصلها للانتحار. صح. There was no law in place. لحد أخذت معهم 2 سنين لحد هلأ صار في قانون اسمه سايبر بولينج. هلأ من تقريبا شهر ونص صار، وهيدا بيمنع أي إنسان إنه يستعمل التكنولوجيا لحتى يهدد إنسان تاني إنه بده يأذيه جسديا أو ليهددوا بطريقة نفسية. يعني مش عم بيهددوا إنه يأذيه جسديا، بس عم بيحاول يحطمه نفسيا. فالقانون بيقول إنه إذا اللي عم يقرأ هذا الشيء عم يشعر إنه ممكن في احتمال حتى لو كان قليل إنه ينأذى إن كان جسديا أو إن كان نفسيا، بحق له يروح عند البوليس يقدم بوليس ريبورت، وممكن ساعتها اللي تعدى عليه واللي ارتكب التنمر إنه يقام تشارجز من قبل المدعي العام البروسيكيور ضده فور سايبر بولينج. إذا كانت الإصابة خفيفة السايبر بولينج هي جنحة، وهي لحد فيها حبس لحد 93 نهار. وإنما إذا وصلت لسيريس انجري مثل هيدي البنت اللي كوميتد سويسايد اللي انتحرت، ساعتها بتصير فلني، يعني فيها حبس أكتر من سنة. بالإضافة المحامية كيتي بليك خبرتنا عن تشارج تاني. هيدي كانت موجودة على الكتب بس المدعين العام ما كانوا عم بيطبقوها هلأ. هي اسمها malicious use of a telecommunication device. يعني استعمال أي شيء تكنولوجي بطريقة malicious، يعني بيحب الأذى إن كان جسدي أو إن كان معنوي. خبرتنا وهيدي هي كمان جنحة، بس هيدي فيها حبس 180 نهار 180 days. خبرتنا للأسف شو صار عنا بالمكتب. سيدة اجت لعنا متهمة she was charged with malicious use of a telecommunication device من روتشستر هيل. من بعد ما خبر الخبرية رامي رح نوصل لذات الكونكلوجن إنه سهل إنسان يتهم أو إنه المدعي العام يعمل تشارج ضده for a malicious use of a telecommunication device. هيدي السيدة لمدة 2 ساعتين فقط دقت repeatedly، دقت كذا مرة للشخص الآخر وتركت له كلام شوي بسيط لمدة 2 ساعتين فقط. اللي عملت تجاهه هيك قدم بوليس ريبورت. المدعي العام بروتشستر هيلز قدم تشارج ضده، وهيدا التشارج اللي اسمه malicious use of a telecommunication device. So القانون بيقول حتى لو بدك تزعج الإنسان you're purposely annoying، يعني شيء كتير خفيف. يعني ما بدك كتير للإنسان لا سمح الله يتهم إنه she or he is maliciously using a telecommunication device. وهون بنحب نحذر المستمعين بسبب التكنولوجيا عم بيصير في قوانين مثل السايبر بولينج اللي هي قانون جديد ضد السايبر بولينج، يعني ضد التنمر عبر التكنولوجيا أو ضد الماليشيوس يوز اوف تكنولوجيا. كمان مرة الماليشيوس
أيضا ندخل بإطارها جمانة يمكن الابتزاز، لما خاصة لما نشوف 2 مطلقين على سبيل المثال أو أزواج في بيناتهم خلاف في فصل صح، فواحد يهدد الثاني على السوشيال ميديا على الفيسبوك ومن
So attorney Katie Plague, he's saying that we see that arising out of family cases. It can happen, right? Where things are heated, everybody starts lovey-dovey, and then when they start going through the divorce, they want to kill each other.
Absolutely.
So we want to tell our listeners who are unfortunately going through family trouble, marriage separation, to be extra careful not to become vulnerable to being charged with malicious use of a technological device.
For the purpose of criminal proceedings, and very much so for the purpose of the outcome of whatever proceedings you may be in the middle of in family court as well. I believe you probably tell your clients the same for the motor vehicle accident cases, Joumana. Correct me if I'm wrong. But what we are telling our clients now in matters of family law is anything you post on any social media site, you have to know that the judge or the referee, if you're in front of the court, will have an opportunity more likely than not to see what you are writing on your own social media platforms, even if you think they are quote unquote private. If anyone has access to them, they can get it to the opposing party or the opposing party's attorney, and they will more likely than not come to the judge's attention. And the judge is more often in our family cases getting repeatedly angry and upset about the fact that couples who are maybe going through divorce or custody proceedings are airing their grievances on social media for no other reason than that it has the potential to affect the children now, because children younger and younger have access to social media platforms, even as young as elementary school, and something that may be stated about one parent or another has the chance to get back to the child. So in addition to possible criminal charges and concerns over that, we want our clients who are going through any potential divorce or custody proceedings where they're going to end up in a family court judge to be very, very, very careful what they are saying on social media. Attorney Mark and I even has gone as far to tell one of our clients to deactivate all of her social media posts because she was having some real trouble complying with the judge's orders to keep her family affairs off social media. And Mark and I sat her down and said, you're going to have to stop using social media altogether until this case is settled.
And again,
because it was bringing such harm to her case.
And let's also clarify that putting your social media on private setting is no protection.
Not at all. Because someone out there may not be a quote-unquote friend, and they give it to the other side.
Yes.
And that's what's happened in our just recent case, that one of the group of people that are
who were on the private social media
was also a friend of the ex.
Okay.
Correct.
And they gave everything to the attorney, and now that's being used in a proceeding with our client right now.
I want to remind the listeners that we are talking for the full hour with Attorney Mark Gazdagi, who heads the Family and Criminal Law Department in our office, and Associate Attorney Katie Plague, who does a lot, takes a lot of calls, has her finger on the pulse of what are the recurring issues from just alone listeners, much less clients.
Correct.
And our discussion took us today in the direction of discussing cyberbullying and malicious use of a technological device. And now we are talking about the use of social media. And I guess our advice against using social media in a family setting or a criminal setting, even if you have it on private.
Yeah, even the use of technology now. We're starting to see in our proceedings, and you also see it with other cases, with other attorneys, that the ability of the cell phone. The cell phone is just not a phone anymore. It's a computer. It's a camera. It's a camera, a camcorder. We have a case going on right now where one of the children of our client actually taped their father for 35 minutes.
Oh my goodness.
Yes.
And a judge or a referee is not going to take too kindly.
Not at all.
For that kind of evidence to even be brought in. I said I advised our client to not even approach using anything like that because it's very damaging.
If that's correct. She had brought it to us thinking it was going to be some kind of advantage over her ex-husband, the fact that her teenage daughter is choosing to record conversations she's having with her father. But in reality, Mark and my reaction was very much so the same, that this is going to be shown to promote a negative relationship between the daughter and her father, and that this is something that would actually cause harm to that relationship and thereby harm harm to our client's case, because I had this written down as something else I wanted to share with our listeners, Joumana. Something that's really interesting that a lot of our clients are surprised about in the family law realm is that there's a set of best interest factors that make decisions in terms of custody and parenting time. And we can go into that at length perhaps at another taping.
We will. And Attorney Mark Gazeki and I have always talked about the best interest of the children. The judge only cares about that. But let me ask you a question.
Yes.
When the daughter recorded the father,
Yes.
Clearly the daughter shared the information with the mother.
Correct.
The mother brought it to your attention.
Correct.
I can understand if the mother is not trying to promote a negative relationship between the daughter and the father, but is bringing concerns about perhaps safety or negative behavior at the home. So you clearly decided not to do anything with that information for now, right?
That's correct.
Is it because you looked at it and you did realize that there is no harm to safety?
That's
but
absolutely.
what was the dad in essence doing for 35 minutes?
Just talking to his daughter about, she would provide him with leading questions, and then the father would
at the direction of the mother?
We can only suspect.
surmise. We can only
Yes.
surmise.
Yes.
And the father would respond very neutrally, very trying to be like a parent. Actually, he didn't even know he was being recorded.
But he passed the test.
Yeah,
he was a good
he
dad.
was like, this is an issue between your mother and myself. You shouldn't be involved in our, and we're like, you listen to that, and then a judge or a referee again would like, this is not in the best interest of the child to be provoked or promoted to try to record your
but to be
conversation.
clear though, there was no violence.
No, nothing like
Absolutely,
that.
Joumana.
If there was any video of the parent hitting the child,
then you would
or
handle it
threats,
differently.
I would
you would find a
100%.
motion
and then what I would have done, the first thing I would have done as an officer of the court, I would have presented this evidence to the prosecution.
Because now there are
now we're
grounds
under
to
an
prosecute
ethical
the father
obligation to
report.
Correct. To be clear, if we have evidence before us that any child in any or one of our clients is in any kind of dangerous or violent situation, psychological, traumatic, or physical, absolutely we would act on that. But in this case, we think it was more the mother trying to perhaps create, even though she's our client and we're supporting her and working out the best case for her, absolutely, was trying to drive a wedge between her children and their father. And one of those best interest factors, Joumana, that I know you and Mark have discussed.
I love how you put it, and I haven't heard it being said like that before, using whatever to promote a negative outcome, such as distancing the father from the daughter.
That's correct. And part of me...
No judge is going to look kindly on that.
That's
no
correct.
Referee, no friend of the court.
Not at all.
A lot of our clients, Joumana, I found over these phone calls that you and I have discussed with screening these calls, I repeat this weekly at least, a lot of our clients are shocked to hear that one of the best, quote-unquote, best interest factors, and this is law in the state of Michigan, is the willingness of your client to promote and foster a positive relationship with the opposite parent. That is one factor that the judge almost always considers when determining who best to have more custody and parenting time. And so we are constantly reminding our clients that, believe it or not, as shocking as it may seem, part of your job as a parent is promoting a healthy relationship with the other parent. And sometimes, now, aside from the child being in a dangerous situation, absolutely, that's a different matter entirely, as you and Mark have stated. But oftentimes, the other parent may parent their child in a way that our clients may not 100% be on board with all the time. And that's just a part of co-parenting in today's modern society. So we're constantly reminding our clients that that is part of the law when determining custody.
What we're seeing now with cases, not only our cases, but in court, you're seeing that the parties in a family law issue, they share paperwork with their children if they're like teenagers. They think that they're adult enough to understand what's going on, and it's not right.
Not appropriate at all.
It's not appropriate at all in the best
and nothing
interest
that a
factor.
judge would take
Again, for that
kindly to.
factor of trying to promote a positive relationship with the other parent.
So you have to be careful because the family law judge is someone who cares first and foremost about the well-being of the children, and engaging in this kind of behavior is not going to earn you points with the judge. It's exactly the opposite.
Correct.
And in a family law setting, there is no jury. The judge is it. She or he is the trier of fact, and she or he is who applies the law. So there is one person whose trust and respect you need to earn and want to earn, and that's the judge.
And in addition, Joumana, just for our listeners to know, and if our listeners have gone through family court proceedings themselves, they'll know this. A lot of our clients know this about the involvement of friend of the court. And friend of the court is a subset of the family law system that is not run by a judge but by a referee, who more often than not is an attorney or a social worker, someone who has a strong background in family relationships, and their purview is the well-being of the child. And that referee will get to know the case very well and make recommendations to the judge, because the referee's decision is never final. The judge's word is. But more often than not, the judge and the referee have a very close relationship.
And a relationship of trust.
Yes. Absolutely. And we've written blog posts about it, Joumana, on our website, and I encourage the listeners to seek out our previous blog posts about friend of the court and referees and the role that they play.
So we're talking about the use of social media.
Yes.
And what is the advice that you give somebody who is today in a consultation with our office and who is considering a separation or filing for divorce as far as social media? What's your advice?
Genuinely, the little you're sharing in regards to your very intimate family matters, the better. Because again, as we stated earlier in the hour, Mark and I remind our clients that anything that you're putting out there into the internet
will be used.
Yes.
Especially in family court, because family court enjoys a lot more freedom.
They have a broader reach.
A freedom of evidence rules. You can use almost anything.
Yes.
So it doesn't have to pass the rule of evidence.
It doesn't have the same
even if it's
protections.
hearsay and whatever, they're looking at the substance.
That's correct.
More than how the information was obtained. This isn't a criminal setting.
That's correct.
This isn't a civil setting. This is a family setting. It's a court of equity.
There are
Wants
less
to look at
protections.
okay.
Yes.
I like that.
Yes.
I knew that, then I forgot that. So the rules. Go ahead.
You know, when your child or you take a picture or you take a recording, or even I've even was in court one day and I saw a colleague of mine try to convince a judge that I gotta remember what the term is. They did a characterism of the other parent, and the parent who has physical custody of that child knew about it but didn't do anything about it when she published it on the internet.
Something making fun of the other parent is what it
fun of
sounds
the other
like.
parent.
A graphic
and
or a
the judge
meme.
did not like that 1 minute, because it's again, you're not promoting a positive relationship or a view of the other parent.
So, given that most divorces are very acrimonious, the use of social media can become very dangerous.
Oh, very, very
Absolutely.
dangerous.
Can be very detrimental and can only prolong further proceedings, honestly, between the parties. And, you know, we spoke about something about friendliness and cordiality in these proceedings, Joumana. And while absolutely you have to be a strong advocate for your clients at all times, you know, genuinely, Mark and I care about our clients and about their families.
Because you are an attorney, and what else are you?
Counselor.
And you are
counselor
a counselor.
at law.
So let's talk again about that. Mark and I talked about that. Let's talk again about that. In addition to being an attorney, what does it mean, Attorney Katie Blake, to be a counselor to someone who is going through a divorce and has information on the other person and wants to use the kids or what have you?
To me, Joumana, being a good counselor in addition to being a competent attorney means that you want to advise your client in a way that is, believe it or not, even though it's my job and I'm a lawyer and we get paid to go to court for our clients, I don't want to see families, especially families with young children, have their case be carried out in family court for months and months on end.
But why is it that the detrimental use of social media can prolong proceedings? Why is that?
Because if it leads to subsequent motions, and there are several cases that Mark and I are dealing with right now, that it's either during the divorce or after a divorce, it's going to lead to continued motions. And a motion is a way that you're bringing the court's attention to something that the other party may file, whether or not it's on our side that we have to do because the opposing party is doing something on social media inappropriately,
or whether it is
or it's coming against our clients.
Yes,
absolutely.
And what usually happens with these motions is it usually sparks an investigation from the friend of the court, and that can take months.
Absolutely.
What kind of an investigation would the friend of the court engage in?
Well, it's along the best interest factors, but they're saying, okay, what's going on?
Well, sometimes they may send the
why
children to a doctor.
Why are they doing this? Why are they surreptitiously recording the other parent? Why are they making caricatures of family members? Why aren't they? Why is the child not communicating with the other parent?
And if and when a friend of the court investigation is sparked, we want our clients to know that it's almost a no holds barred situation. And when I say that, I mean that almost everything, every communication, every relationship in your life and your child's life will be brought to the friend of the court's attention. It works a little differently depending on what court and what county you're in. And it's partly our job to know that and know what to expect. In some instances, it may trigger a home visit where one of the friend of the court investigators is speaking to your child depending on their age at home. They may ask you to make an appointment to bring them in and privately speak to the friend of the court investigator. And the other parents are not privy to what might be said during this discussions because, again, the court wants to protect the child. They can speak to other family members. And yes, Joumana, you're correct. In some instances, the friend of the court may order a psychological evaluation on one or both of the parents to determine what kind of fitness, moral and parental and otherwise, that these parties may have. And while sometimes an investigation is necessary for the friend of the court and later the judge to make the proper determination in terms of custody, if it can be avoided, more often than not, it will better serve the families that we work for if we can do what we can to settle it outside of such a lengthy and a very probing proceeding, such as an investigation.
And I want to add that going through divorce may be very, very hard, and emotions are very intense. But both mother and father need to realize that their relationship with their child, the duty to pay child support, may end at age 18. But truth be told, that the relationship of the child or the children with father and mother will only end upon death. So we're looking for the long haul. This is a long, long relationship. Granted, at the moment of divorce, if God forbid you're the victim of cheating, or you're going to be hurt, you're going to be upset, you're going to say maybe things you will regret later. But at the same time, you're going to be in each other's lives for the rest of your life regarding your children.
That's very beautifully said, Joumana, and you're absolutely correct that it most often is not going to end at the age of 18, and even up until the age of 18, where child support is required and the child will remain the jurisdiction of a family court proceeding, especially with parties with young children. We have to remind them at every interval through a divorce proceeding or a custody action that can take place outside of a divorce proceeding that no matter what I do, no matter how professional and positive results we can bring to the clients, at the end of the day, they're going to be the ones in charge of their family's destiny and their children's destiny, not the lawyers, because the attorney-client relationship is going to be far shorter than that of the parenting relationship between our clients and the opposing party.
And that's why we, at our firm, we try to do our best to navigate all the emotional issues with the legal issues and try to work out the best amicable solution we can for our client, because it saves you heartache, time, and money.
Absolutely.
And you know what saves you even more heartache, time, and money? I mean, what is the incidence of divorces upon a first marriage? They are in the high 60, 65?
65% right now.
Okay. And the incidence of divorces On a second marriage is even higher.
Even higher.
Okay, and a third marriage is even higher. Attorney Mark Gazdeki and I, we've talked, Katie, before about how important it is to enter into a relationship for the right reasons before you get married, to enter into the right relationship with the right person for the right reasons. The right reasons aren't to have a roof on your head, and the right reasons aren't to get a green card, and the right reasons aren't because it's time to have a kid, and the right reasons aren't because I want somebody to cook and clean for me. The right reasons because there is enough in common between two people who have taken the time to know each other and who are not in the relationship to use each other, but to serve each other, to help each other. They have to have enough in common, especially as it pertains to the big things, religious matters, major life decisions. I think that when you take your time to get to know the person, and when you're marrying that person after studying them for a while for the right reasons, the incidence of divorce is going to go down, and the likelihood of children becoming the victim of divorce is going to go down. It's old-fashioned advice. It is general advice, but it is very, very, very true. When you take your time, and sadly I say that from talking to people in the community, a lot of people enter into marriages for the wrong reasons. One is dependent on the other, codependent on the other, and it leads to resentment, it leads to disappointments, it leads to anger, and it leads to separation and divorce.
And one thing that's nice, in my 27 and a half years of practice, I've had, through counseling, being an attorney and counselor, through the counseling aspect, I was able to reconcile two divorcing parties about 4 times in my life.
That's wonderful.
Just one of
really wonderful.
It doesn't happen often, but they start saying we just lost our way and we forgot how to communicate with each other.
Just one of the firm's clients, Joumana, just at the end of last year, in fact, also dismissed. Our client was the father. He dismissed his divorce case, his divorce action. Still, paid for the attorney, paid all of the court fees necessary. But what happened was we got a court order to benefit him in Macomb County Circuit Court, where the referee ordered that he could see his children 2 or 3 nights a week, despite the fact that the mom was trying to keep the children from the father. And the moment we got a judge to order that during the divorce proceedings, the father had a right to see his kids on a regular nightly basis as well, that kind of led to the mom in this case to have a change of tune and want to go back to dad. And I think they worked it out for the right reasons, for the benefit of the children.
For the right reasons and for the benefit of the children.
I don't think the mom realized, honestly, the opposing party realized that the father would have a right to see his kids through the divorce proceedings as well. Times are changing. It's 2019, and courts do not assume that the children are always best with the mom at all times anymore. And so once mom had to deal with the reality that her kids were going to be away from her for at least a couple nights a week, I think it motivated the family to come together. They had 2 very young kids, a 2 and a 3-year-old, and it motivated the parents to want to come back together for the right reasons, for the good of their kids, so they could be raised in the same home. Yes.
Very good. And I hope that this relationship continues with time and improves. And the several marriages that you have helped restore, that's a huge blessing. Have you kept in touch with these people?
No,
do,
ma'am.
Do you know that they continue to have?
Well, one couple I did, and I knew them, and they had grandchildren, and I helped them with some other civil actions later on in life, like a house issue they had, and representing some of their children. And then, unfortunately, they're both passed now.
I see. I once was talking with a family law attorney, and she did say to me, and it's got stuck in my head. She said, just because you can fight a fight in family law does not mean you want to fight the fight. Costly, not good for the children, results in protracted proceedings. It prolongs things.
That's exactly correct, Joumana. And I've had lawyers with many years' experience say something very, very similar, Joumana. And, you know, we are family law attorneys. We handle divorce and custody matters. And oftentimes it is necessary and is required to have a great advocate on your side. So by no means are we telling you that, you know, we're not here for you and to protect your rights when a lawyer is necessary. But it's also our job to be compassionate and sensitive human beings and encourage our clients to lead their best lives for themselves and their children.
So part of what you do when listening to clients when they come in is to determine to yourselves whether there is a real breakdown in this marriage or whether this relationship can be salvaged. Because I am sure that's part of it. I'm sure you would not be shy, and I know you both are very ethical people, in bringing to the attention of the person, is there a possibility of reconciliation? Can you work on this?
All the time.
Are you exactly?
Yes, ma'am. That's correct. That's absolutely correct.
That's what we try to do.
Wonderful discussion. Thank you for being here today. I'm glad that you came, Katie.
I enjoyed myself very much. Thank you so much for having me, Joumana, and to CINA Radio.
And she let you talk a little bit.
I know.
Well, I had to advocate a little bit for you. I don't know if you noticed. Because she's very, very, very fluent and outspoken. And God willing, I would like to have you over next Thursday again so that we can continue this discussion.
Thank you.
Attorneys Mark Gazdagi and Katie Blake from our office, thank you very much for being here today.